I feel she is milking my high-paying job as her business is a startup and doesn't pay her right now.
Welcome in, everyone. This is Mark Reel Jr., the Fathers Rights Attorney. To my right, I have Managing Attorney here at Real Fathers Rights, Ryan Dreyer. And on my left, I have Assistant Managing Attorney, David Taub. And we'll go ahead and hop right in. I'll pass it over to Chandler. He has a question.
Just starting through the process of divorce. 11 years, and she requested this. We have built a nice life with multiple businesses together. She wants to wait until the accounting is done on the business to file. I feel she is milking my high-paying job as her business is a startup and doesn't pay her right now. We are living separated and still share accounts. My question is, can I get a new bank account and have my pay direct deposited to that new account immediately, or should I wait until everything is filed? Meanwhile, she has free access for Amazon and Target runs. She feels free to spend my money as she sees fit. I would love some advice and direction from anyone who has gone through something like this themselves.
This sounds a lot like a lot of the divorces we deal with. This is not an uncommon situation. And so I kind of picked up 5 key points or 5 key questions that I think it'd be really impactful if men knew the answer to. And David, I'll start with you here. The 11 years pops out at me. Can you explain what an 11-year marriage would mean in the state of California?
Sure, Mark. Thank you. In the state of California, 10 years is the demarcation line, normally, between short-term marriage and a long-term marriage. Now, that's the easy answer. It depends also on your relationship with your wife. Who was working, who was at home. Were you the person writing in supporting her at the time? It sounds like there were dual businesses going on. Yeah. But I'll tell you, in an 11-year marriage, the judge can still look at the circumstances of each marriage to see if both spouses were working or if one of them was staying at home to decide whether it will qualify as a long-term marriage. I can never say it's a slam dunk 100% long-term marriage. As the old adage goes, sometimes it depends on the facts. If you have two clients that are a client and an opposing party that are both working full-time and they're both bringing in income, the chances are greater that with an 11-year marriage, actually less. I'm correcting myself again. The chances are less the judge might require spousal support to be paid for the long term, especially if the parties are still young, they're both capable of bringing in income. The judge may not want to shackle the party that is earning less to be receiving spousal support until there's a remarriage or a death of one of the spouses or further circumstances.
Yeah, and the long-term marriage in the state of California is a big deal because you mentioned the spousal support. If you have a short-term marriage, typically it's going to be half the length of the marriage.
Right.
Once you clear that 10-year mark, that's kind of the line of demarcation in general. It's the rule. It's not a certain thing. But you have spousal support, or some states may call it alimony, that will not have an end date. And if you want it modified, you're going to have to go back into court. So that's a big one. And for me, in this scenario, it talks about, he mentioned she's running her business, it's not making any money. Has she made money and over the course of their marriage? And if she's been a stay-at-home mom or she hasn't contributed, he could be on the hook for quite a bit of spousal support, and it could be indefinite.
Yeah, and I think an important fact here is to look at, since she is running the business, could she be doing something else? In another way, saying, should there be imputation of income? Because she is divesting herself of going out and working for a company maybe for $10,000 a month. But what she's choosing to do is say, in the future, I'm going to make more. Well, can she do that and force her husband to pay for that choice? And I think a lot of times the answer is no.
And that's a good point. Like if she is we'll just say if she's a marketer, if she has done something in the business world and she's off consulting now trying to get a business off the ground, but she could go make $250,000 a year as a consultant at a big firm or whatever. That's something that's going to take into account too.
Yeah, I think the point is you don't have the right to divest yourself of income producing potential. And I would also like to show you guys, it's not 10 years is the magic line, which was what David was getting to. Right. I've actually had a 9-year, 2-month marriage considered a long-term marriage in Orange County after a pretty long trial.
Yeah.
The devil's in the details.
And conversely, I've had a 10.5-year marriage in which the judge said to the non-working spouse, you're in your late 30s, you're bright, you're capable of working, short-term marriage, half the length of the marriage.
Yeah. But that's something definitely you need to get in and get ahead of because, like I said, if she's not making any money and you're over that 10-year mark, you could be in a world of financial hurt in the long run.
Well, yeah, and you're going to get hit for temporary support.
Yeah.
Let's be clear about this. We're talking permanent support.
Yeah.
Temporary, they're just going to run the status quo numbers as they exist at the time.
And here's the last thing on that. This party has not filed yet. The clock is ticking at this point. If she's going to take another year or so to get the accounting done and to drag it out, it's going to be a greater and greater chance to be a long-term marriage.
Well, and here's the piece too, and this is another note I made at the end of the question. He mentioned they're living separately, so that's going to be a big point of contention, and I'll pass it off to Ryan in terms of the marital economic community, and we'll talk about the businesses here in a second, but if you're living separately, can you talk about the arguments you would have that the parties have already formally separated and the marital economic community has ended?
Well, I mean, that's a huge one. Now, we all have different, and some people have very weird marriages, right?
Yeah.
Two parties can be married and living separate. Has one person given an overt act, I am done with the marriage. So we have the statement, unequivocally, I'm done with this marriage, and an act in furtherance of that, which would be moving out. The next would be rolling into, and I don't want to get ahead of ourselves, separating bank accounts. It just needs to be an objective act in furtherance of your intent to terminate the marriage.
Yeah. A lot of times the most common one we see is a couple slept together and they move into separate bedrooms. Now, some couples sleep separately, and that wouldn't be an indicator. So once again, devil's in the details on it. But that's an interesting fact that if you're going through this, the fact that you have, sounds like in this instance, they've moved out of the house they were living in, or one of them has left the house they were living in, that could be a big deal in regards to the marriage being considered a long-term marriage or when that marriage ended for purposes of community property. All right, so the next piece that really popped for me and would be a huge piece of a divorce in the state of California is he mentioned multiple businesses and having built a nice life together. So I'll pass it to you, David, and for everyone, explain to us what the marital economic community is in the state of California.
Sure. Well, the court is going to look at the time of marriage, what was going on between the parties, who was running the business. Were they both? Were one of them? And it may take a detailed look, month by month, year by year, as to how much did each side participate in terms of work effort, in terms of income brought in, but many factors to see whether this was a team effort or whether one party or the other was the primary manager or mover in this business.
Yeah, and definitely, and to roll back on that is like California is one of 9 states that is a community property state, which what that means is everything between date of marriage and then date of separation is your marital economic community. So all assets, all debts that are acquired during that time frame are considered equal property of both parties in general. And so when we talk about that in a business perspective, sounds like they grew businesses over the course of the marriage. Maybe these businesses were founded before marriage and they grew during marriage. Ryan, can you talk a little bit about what would happen if you founded a business during the marriage, even if your spouse wasn't involved? And what happens if you, say, founded one before but then grew it substantially during?
Yeah. So, again, all your labor, your creativity, everything that you can put forward is owned by the community during marriage. So
you become one.
You become one.
When you get married, you become one.
It's a single economic community. Mm-hmm. So say one spouse stays home, or heck, they work at McDonald's, and the other one is the CEO and the founder of a business. If that business was started during marriage, it's community property, and all the other assets that that business acquires are also community property. It doesn't change its nature. Now, if you started the business prior to marriage and then continue to use your labor and everything else, so not just assets appreciating, but actually your labor goes into the management of those assets or the management of the business, then there's going to be a community property portion, which will then require us to do a valuation of what percentage of this business is separate property and what percentage of this is community property. The valuation, I'm not going to get into it. It's called Pereira or Van Camp. And they're the ways that we look on it. That's a subject for a much deeper dive with the forensic evaluator.
Yeah, definitely. So in short is, if that business is founded before marriage, then the portion that existed prior to marriage in general would be considered separate property. But any value and gain or any labor that took you away from earning money elsewhere would be considered community property. Correct. So yes. That's a very, very big distinction, is that it really matters if it was founded before and after, and then what value was created or what labor was put into it during the marriage. This is where we see a lot of entrepreneurs, a lot of business people get into trouble because they maybe invested 10, 15, 20 years into a business, and if there's no prenup in place, if there's nothing, and that business grew by $20 million, you may have an 8-figure check or an 8-figure payout in some form or fashion that needs to occur. So the last piece, and I think this is a big one that you can get yourself in trouble with really, really quickly. He asks about, can he deposit his checks into a separate account? I'll just tell you the short answer is yes, as long as divorce hasn't been filed yet. So David, I'll pass it off to you. What if divorce has already been filed for in this matter? Can he do that?
No, he cannot. There are certain forms that you're going to be serving the other side, and one of them contains wording called an ATRO, Automatic Temporary Restraining Order. And that's a limitation on what you can and cannot do with your assets, with contracts with the community and third parties. In other words, if there's a joint checking account and you have served the other side divorce papers, you cannot close out that bank account anymore. You cannot change an insurance policy personally or on the business that the community shares.
Close a credit card, close a line of credit.
Correct.
Change who or demand that they start paying something that you traditionally have paid. Once that divorce has been, once you've filed it and then once you've served them, status quo must remain on all financial aspects of the divorce.
Now, I'm going to put in a proviso there also. Yeah. Before the marriage, let's say this person has a scenario where there's, say, $100,000 in a bank account, and they decide to take the money out one day before they file and serve it on the mother. There are codes in family law that call for a duty that you have to even a spouse you want to divorce, a duty of loyalty, in which you cannot gut a giant bank account and put it into a separate account away from the spouse, at least in the long run. They're going to know you did it. That asset's going to be recognized. And if you try something sneaky, you can not only have to disgorge or give back that amount, but also give back your share of that community property account if they find you did it on purpose to take assets away from the other spouse.
Yeah. Doing something to prepare yourself for divorce like that can get yourself into a bit of a gray area. But if you're in no man's land with it and you don't know what's going to happen and she says this and nothing's moving forward, generally being clear, my advice would be talk to a professional about your specific situation, because they'll be able to provide more specific guidance, because every situation is different. But yeah, definitely big no-no of, we see this all the time, that it's usually the wife. All of a sudden, tens of thousands of dollars will go missing from a retirement or a bank account, and they'll be like, I didn't know.
You know what the best thing is to do? Take half the amount out before.
Exactly. Just remember, everything will be accounted for, and if you take it and you can't account for it, you go into what we call a breach of fiduciary duty as well. Yeah. But yes, he does have a right to open up account and put his paycheck, if they've separated, It's not community property. He can put it into
Yeah.
his own account.
That money that's already been earned and is sitting in there,
Sure.
that's going to be community property, period, because it was earned during marriage. But anything moving forward, especially if you guys are going to have a date of separation prior to that, she has no entitlement to your future earnings. Outside of, in this case, there may be some spousal support.
You just remember, community property doesn't just lose its nature absent a waiver, right? You can't put it into a bank account in your own name, and now it's magically your separate property.
You see that with houses a lot. Well, my name's the only name on it.
It's sure, and we could do a 3-hour podcast on the presumption of undue influence when you execute title documents in a marriage, but that's neither here nor there. No one asked that question.
Definitely. Well, gentlemen, thank you so much for spending some time with us today. The viewers and listeners, I hope you found value in our conversation. And as always, we'll see you guys next week on another episode of the Fathers Rights Playbook.
Bye, everyone. Thank you.
Good night.